in this case, Your Honor, we've negotiated to an impasse. At this point, there's certain concessions Ms. Fed needs or is requiring, and those concessions the state's not willing to make. So as I explained to her, that's what a jury's for. So we'll just set this on a jury trial, Your Honor.
Okay, what we'll do.
I've got February. I've already got at least one, maybe two. We can do it in April.
I'm thinking April.
Okay.
So what we'll do. You got a question, Ms. Fed?
Yes, sir. It's like, could I do like 5 years probation and anything to let me be like the PTI so I don't end up a felon? I'm 22 and that's my biggest thing. I will do probation for like, it doesn't matter how long, just to end up not being a felon. I don't want a title on me the rest of my life.
I don't get involved with plea negotiations. That's between your attorney and the state. And a PTI, that's something completely up to the state attorney's office, whether or not they want to allow you into their intervention program. I don't get involved in that at all. If you want me to sentence you, what I'm looking at, I'll listen to your attorney, I'll listen to the state. And
the problem with that, Your Honor, is if you sentence her, it will be to a plea of fleeing and attempting to elude. That is by statute.
Is that a second degree?
It is, but by statute, you have to adjudicate her.
Yeah.
That's what I told her. It would be against the law for you not to adjudicate her as a felony.
I don't know anything about you, but the law is the law. And if the law tells me that I have to adjudicate you guilty based on the charges, I'll have to adjudicate you guilty. I can't make any exceptions not to apply the law. So
what about the no contact? We have been together the last 5 years. We work as a team every day.
That's with her co-defendant. And again, as far as I know, the state's not moving from that.
Every day in the same house.
They have children.
Taking care of our 1 and 2 year old children.
We can change that to peaceful contact like we did for him. That wasn't one of the things I was asked, I don't think, but.
It was definitely asked.
Okay, so it would be peaceful contact.
Judge, if I could put something on the record.
Yes.
As well. Judge, Mr. Wilson has worked very hard on this case. He's talked to me about this case probably more than any other case he's had, Your Honor. So I wanted to be sure that was on the record. There's been a lot of concessions given, and we got to the point where no more. So I'll give Ms. Fed a little time this morning if she wants to speak to Mr. Wilson, but the plea offer as it stands is it, or it's being taken off the table today, Your Honor.
So did I hear you right that you were willing to do a peaceful contact with Mr. Clemens? That may tilt us in the right direction, Your Honor. Let me talk with Ms. Ms. Fed, and maybe we can resolve this today after all.
yeah, Ms. Fed, I'm looking at the information. It's a second degree felony. If you
So
want,
there's no way I'm going to get out of this any type of way without a felony.
no. What I'm saying is, Mr. Wilson and Ms. Smith can negotiate a resolution. You can go to trial and let a jury decide whether or not you committed these offenses, or the state can prove that you committed these offenses. And you ask the question, can I sentence you? I'm looking at the information. If I sentence you, it's a second degree felony and I have to adjudicate you guilty. Not saying that I have to send you to prison. I'm not sure what your score sheet is, but
felony title regardless.
but
There's no way.
if I sentence you based on this, you're gonna be a convicted felon.
Well, either way, it seems like I'm going to be a convicted felon.
I don't know what the plea offer is.
That's what I'm saying. I'm trying to see if I can do like 5 years of PTI, where you do, so I don't end up a felon.
I can't say yeah and they're on the PTI. That's up to the state.
That's not the offer they've made. That's what I was trying to tell you. The judge can't do that. So I've changed this to peaceful contact with both these people. And it's otherwise what we discussed. If you don't want to do that, we can put you on trial.
She won't even let me do 6 years of probation to not be a felon anymore?
Ma'am, she won't let you do anything else. That's it. She just told me you got.
My hands are tied.
There's nothing you can do.
That's it.
No amount of PTI. So I will not have this felony title on me for the rest of my
You
life.
need to talk to your attorney, but you do not qualify for PTI. That's the offer.
And it's going to be worse if I go to trial.
You can always be found like, man, let's step. There's people trying to work.
Ready, Mr. Peters?
I'm ready, Your Honor. Mr. Willie Hill. Your Honor, back before you was Michaela Fed, again, in case numbers 2399 and 23100. In 2399, Ms. Fed will be pleading, it'll be no contest, but she will be, as we discussed, adjudicated guilty. She's pleading to count 1, the fleeing and eluding, which is a second-degree felony. Count 2, the resisting without violence, that will be consolidated. Count 3, the possession of paraphernalia, should be pleading to that. case as well. Then in 23-100, it was originally charged as a felony battery over 65. She'll be pleading to the misdemeanor battery. So that is now a first-degree misdemeanor. She should do 2 years of community. Again, she's adjudicated. She should do 2 years of community control with curfew and ankle monitor, followed by 2 years of regular probation.
I didn't get the ankle monitor part. I'm so sorry.
Oh, no, you're fine.
Come
This
on,
is-
why who's gonna hire me?
This is your
Being a
life.
felon with ankle monitor.
Yeah, can we get a trial date?
I want to. I need some more time to talk. You want to come back?
I was told that she's now probably a minute over the deadline she had to accept this offer.
Ankle monitor for how many?
Judge, at this time, the state withdraws that plea offer that was just read out by Mr. Wilson and requested trial date.
I told you what you were gonna do.
Ms. Betty, you need some time to talk to Mr. Wilson. The state looks like they want to pull this off the table. You can accept the state's offer. These are your options, Ms.
Can
Betty.
I ask you personally, which one do you think is gonna be worse?
Ma'am,
Do you think it's gonna end up way worse for me?
I can't predict
Also against the law.
I can't predict the future. I'm not sure what a jury's gonna do. I don't know any.
I need to go to law school.
Miss Faye, listen, ma'am. Miss Faye, listen. I don't know anything about the facts of your case other than what I've read in the complaint affidavit. So other than what the police said, that's the only thing I know. You have a good lawyer. He will if you go to trial, he will represent you. He's done it hundreds of times before. He knows exactly what he's doing. I don't know what a jury would do. That's one option. The second option is to accept the state's offer. What will happen, I'll ask you some questions to verify this is exactly what you want to do, that you're doing so willingly, no one's twisting your arm, that you know what you're doing, and I'll accept that. The third option is you can reject the state's offer, say you don't want to go to trial, and you can say, Judge Collier, sentence me. Again, I don't know anything about your background. I don't know anything about you. I can tell you with the information that's charged, you have a second-degree felony, and the law in the state of Florida is I cannot withhold adjudication on a second-degree felony. So I will adjudicate you guilty. You'll be a convicted felon. The other conditions, whether or not I send you to prison or probation, I don't know. I'll tell you, the last time someone appeared before me with a high-speed reckless fleeing or attempting to elude, I'll just say this, he's not home, and he ain't coming home for maybe another 6 years or so. Not to say that's going to happen to you, I don't know.
So it's serious, and it's a very serious matter.
It is very serious.
Okay. A second. Okay.
Can I proceed? So it's the 2 years community control with curfew and ankle monitor. There is nothing else, and everyone in this courtroom is waiting on us. We're acting like a couple of fools up here.
No, you're fine.
Can we get rid of the ankle monitor? What is the ankle monitor gonna help me?
Ms. Fed, don't talk to me anymore. You're represented by counsel.
This is inappropriate.
Y'all want to come back? We'll leave that open until tomorrow. No, okay.
Did you not take it, but I just feel like, come on, what is the ankle monitor gonna do?
How I can't get involved in the plea negotiations. That's Ms. Smith. Ms. Fed is asking that you remove the ankle monitor. The answer, the state said no.
That's right.
Okay, it's on the record, no.
Okay. I wear the ankle monitor. Cuter.
Court costs and fines, restitution that says to be determined. There was no damage that I know of, but there could be investigative costs. I don't know. $100 public service, cost of supervision, drug and alcohol evaluation and counseling is recommended, zero tolerance. DMV may apply additional penalties, time served on misdemeanors, DNA sample, testify truthfully against Ricardo Clemens, no only peaceful contact with Deborah Williams and Ricardo Clemens. Count 2 is resisting an officer without violence is consolidated. I believe I already read that into the record. Is that your understanding of the plea, Madam Prosecutor?
I'll try to get through this. Ms. Fed, you raise your right hand for me.
I'll pass that.
Except What am I supposed to say?
Thomas Burke, the text say shall give you the truth, the whole truth, and nothing but the truth, so.
Ms. Fair, is this what you want to do, ma'am?
No,
Okay.
but it's what I gotta do.
No, it's not what you got to do. If this is not what you want to do, I can't accept your plea.
I just don't understand why. I'm gonna be a felon. I'm gonna be a felon, obviously. So what does that mean? I'm gonna do?
That's not the case. You can always go to a jury trial, and I can tell you, listen, I've been in trials, so I thought a jury's going to come back with a guilty verdict. They come back not guilty. I've been in trials that I think they're going to come back not guilty. They come back guilty. You never know.
So you're telling me I could take it to trial and still end up not being a felon? There's a chance that I could get out of this without being a felon.
You can go to trial. The state will have the burden to prove the case against you. Mr. Wilson will stand up, cross-examine.
Let me trial.
Okay.
Let me trial.
Okay. I think based on what's happened today, and Ms. Fair basically telling me she doesn't even want to accept this. I don't think it would be no unintelligent voluntarily entered into even if I accepted it.
That's kind of what I thought we should.
So what we're gonna do?
I'll make it work for myself.
We're not saying you'll make it worse for yourself. That's a right that you have. You never know what's gonna happen. So what we're gonna do?
You can destroy that.
Ms. Fed, we're gonna place you on the April trial docket. That's 4/15, and we're gonna come back. Y'all gonna come back in March 8th.
Judge, there's, the pleas off the table, there's no need, Judge, we can just put her on the April trial, management and April trial.
I don't have an April trial management. That's all.
Okay, that'll be fine.
And I was gonna start putting the trial management the month before trial to give you an opportunity. Because usually we fill up that trial docket and give the state and the defense a chance to see exactly what's gonna go to trial. So we'll we'll place you on the 4/15 trial docket. We'll bring you back March 8th at 9:30 for trial management, okay? All right, Ms. Fay, just make sure you stay in contact with Mr. Wilson. I know this offer may not be what you want. He's a good attorney. Stay in contact with him because you're going to be in trial.
Because then if I take it to trial, like the battery, every charge will be on trial, right?
That's correct. You'll be facing
So
everything. There'll be no amendments.
But we wouldn't try them both together. So, but the state would choose. But right now, you're charged with aggravated battery on the first note of the 65.
Exactly, and that's what's scaring me.
And the state will basically decide whether or not to take that to trial or take the Felon or tip into elude to trial. And we'll talk about that in March.
So y'all will decide to take it to trial?
No, you have two different cases. And the state, we're not going to try both cases during the same week. So the state will either say, Judge Carter, we're going to take this case to trial, which is the Felon or tip into elude, or we're going to take the aggravated battery to trial. So they'll.
And just like that, the courtroom reaches a turning point. She chooses trial, but now the stakes are even higher, because the original plea deal is gone and the prosecution can pursue the charges as filed. The judge has made one thing crystal clear. She cannot guarantee the outcome, and neither can anyone else. So what would you do here? Take the certainty of a felony conviction under the deal, or gamble on a jury and fight for a different outcome?